Welcome back, everybody. We're going to do contracts part 2. Again, we're going to move on from the beginnings of contract. We talked a little bit about what the 6 elements plus writing being the 7th element, if writing is required. And then we're going into, we did offer and acceptance, more details of things. So now we're going to go into more detail on the other elements of a contract. All right, so again, let's kind of go over those. We have the offer, which is, as you remember, right, the story we were using or the deal we were using was I offer to sell you my bike for $50, right? That's the offer. The acceptance is I agree to buy your bike for $50, right? That's now we've got an offer acceptance. We both have given up some sort of consideration, right? Mine is giving you the bike, you is giving me $50 of your hard-earned cash, right? It was all done at the time we made the deal. So we have consideration and everything done. We have legality we've talked about where it has to be legal. It can't be doing a drug deal as far as having a form of contract regarding drug deals because the court's not going to enforce that contract. You have to have the right mind, right, capacity to enter into a contract. You can't be a minor. You can't have your, some situation where your brain is deteriorating or whatever it might be. Consent means nothing fraud, duress, or anything like that. You have to willingly agree to enter into that contract. And then in some instances, a writing is required. All right, so let's go into more detail about consideration. Remember, consideration, the key is it has to be the consideration done at the time in which the parties entered into the actual agreement. So here's the general rules. Both parties must get something of measurable value in the contract, right? You notice that term measurable value. We'll talk about a little bit about the peppercorn rule. Peppercorn is a spice that your parents may use. Sometimes you'll see it in a pepper shaker where you have to grind it, right, to get the peppers to come out. All right, those little, there's an old decision by a judge and said, as long as there's a value of a peppercorn, then that's enough to have some value and the court's not going to step in. We're going to figure everybody are big boys and girls when they enter into a contract. So long as all the elements are there, if it's a lopsided contract, so be it. Everybody's got to do their due diligence, but the court's not going to step in just because it's so lopsided when both parties consented, capacity, and everything else was right. So both parties must get something of measurable value in the contract. There has to be a promise to give something of value is consideration, right? Let me say that again. A promise to give something of value is consideration, right? So it could be, I promise to give you $500 when I get that money. I don't have it now. I haven't given it to you now, but I'm going to give it to you in the future. It could be because I am purchasing from you. I'm opening up a restaurant. I need big ovens. I need big refrigerators. So I'm purchasing those from you with the understanding is you're going to get 20% of my receipt, my sales over the next year period of time. So it could be something in the future, or something of value in the future, right? It could be the two parties have bargained for that considered exchange at the time, right? That's the key is everybody had to agree. This was the consideration that each party was giving up and or getting at the time in which the agreement was made. If there was some side benefit or something over here, that's not going to be what the court's looking at, whether or not there was consideration. It was at the time in which the parties reached their agreement, did both parties give some measurable value in that contract. All right, those are the general rules that the court's taking a look at to see if in fact there is consideration in a contract. Now, there is value when you agree not to do something, right? If you have a legal right to do something and you agree not to do it, that does have value. Even though there's not a monetary number or whatever put to, the courts have said that is in fact some sort of value that the court will consider. And we'll talk a little bit about that in that Hammer v. Sedway case that was in your book that is still being taught. Just talked with my daughter. Hey, did you guys have to go over Hammer v. Sedway again? And she laughed and said yes. They still teach that as the ultimate case, the consideration regarding a forbearance, agreeing not to do something. Right? Act is any act legally required to do in the first place, right? And forbearing the doing of that. Not legally required, but legally can do it is probably the better way of saying it. Forbearance is refraining from doing something that one had a legal right to do in the first place, right? So act is any act, that you're not legally required to do in the first place, because if you were legally required to do it in the first place, right, then they're really not giving any consideration because you had to do it anyways. For example, you entered into a contract with the police officer to make sure that if anybody tries to rob your place, they will do an investigation. Well, they were already required to do that anyways, so that would not be a legal binding contract with that officer. Hopefully that makes sense, right? And forbearance is you have a legal right to do something, but you're agreeing not to do it going forward as part of your consideration. All right, those are the general rules of consideration. All right, let's talk about that Hammer v. Sedway case. Let me kind of pop through some of the facts here. It's going to be easier to do it that way versus doing one by one. All right, so it's ironic, but Hammer and Sedway, are neither of the parties that were really part of the original agreement. Hammer is a lady that owned like a furniture or fabric shop, and she sold to William Story, the nephew, a bunch of furniture and stuff to put into his new house with his new wife later on, much later after the initial agreement. So she had the credit, right? She knew that Mr. Story, William Story, owed $5,000 to the nephew, and so she gave the nephew that credit line with the understanding that the nephew had turned over his right to that money to her. Sedway, on the other hand, was the executor of the Story, Uncle William Story's estate. And so as it turns out, this gets started because Miss Hammer has the money owed on to her, to the nephew, as she owns that debt now. And Sedway is the executor, and he refused to pay out the $5,000. And we'll get into his legal reasons why he refused to pay out that $5,000. So here's how it really starts. Back when the nephew, Story, is 16, 17, 18 years of age, he's out and about drinking, smoking, womanizing, gambling, all these things. Shooting pool was one of the things that he couldn't do anymore, going to the pool houses and those kind of things. All these things that were kind of hurting the name of William Story, and it was a pretty prominent family name with a pretty prominent business, and Mr. Story, uncle, believed it was hurt, that reputation was being harmed, and that could hurt the business ultimately. So he went to his nephew and said, look, I'll pay you $5,000 if you stop doing all those things. So remember, nephew had a legal right to do all those things. Back then, a lot more fun times apparently, you were able to do all those things legally at the age he was at, right? And so the nephew says, okay, if you pay me $5,000, I will refrain from doing all those things until I turn 21 years of age. And he did. He stopped doing all those things, became a pretty good citizen, started working for the business. Uncle was pretty proud of him, more than happy to pay out the $5,000 as it turns out. But the next thing the uncle was worried about is turning over $5,000 back then, at the time this occurred, was like handing $130,000 to someone now in today's world, $130,000, $150,000 in today's world, to a 21-year-old. He thought that would just be way too much money to hand over. So he says, look, I'm going to hold on to the money now. You know, as you need it, I'll pay it out, but let me hold on to it now for a bit of time. Unfortunately, then he passed away not too long after that agreement to hold on to the money. So he never paid it out. And so the nephew asked for that money via Miss Hammer, because he knew that he had gotten married, had a wife, got a house, furnishing the house, putting new curtains up, whatever was being done, and had basically used that money to furnish the house, and so had given that debt to, or receipts, I guess it would be, to Ms. Hammer. So Ms. Hammer went to the state, and the executor being Mr. Sedway, and said, could I get that money from you? And he refused to pay it to her. And so that put everybody kind of in a bind, of course. So she decides to sue, right? And in the lawsuit, she says, look, it's clear that he had a legal right to do all these things, and he stopped doing all those things, and the uncle found it to be a benefit because, in fact, he was willing to pay out the money. The executor, who was Franklin Sidway, said, look, the uncle basically got nothing from the fact that the nephew had refrained from doing those things. So there was really no consideration that he had given. And really there was no consideration by the nephew either, because those things were all good for him not to do any of those things. So he really didn't, get a benefit, or if there was any benefit, it was him. Therefore, in either one of those situations, you did not have consideration. Therefore, it's not a legally binding contract, not an enforceable contract. Therefore, no money to be paid out. All right, so that kind of gives you the background of the case. Ultimately, what the court decided was, as you obviously understand, is it was consideration. They said, look, the nephew had a legal right to do all those things. He forbore, right, that act of forbearance, forbore doing all those items with the understanding he was going to get paid that $5,000. There was a benefit to the uncle in the sense of that he wasn't out there, wasn't destroying the reputation of the family, wasn't destroying potential business contacts. Therefore, there was a benefit to the family as well. So in either of those situations, you had consideration, and so the estate had to pay out to Miss Hammer that $5,000. So understand, acts of forbearance or the ability to act are, in fact, consideration. Even though it's not money or anything like that, you giving up your time or you giving up doing something you have a legal right to do, each of those are consideration for a contract. Sorry about that, I went back too far and still trying to figure out how to get back and forth between slides when I'm recording. So, was there consideration is the question, right? So you have to take a look at this situation and say, look, what did each of the persons give up at the time in which this agreement was made? Right? In this particular case here, right, it appears that Son is willing to pay back the $170,000 that was lost, right? And Kim is agreeing not to sue Son, right? So, hey, looks like we maybe have consideration. But remember we talked about, whether or not you have a legal right to do something in the first place. And here, because Kim had invested the money with the understanding that money gets lost, that just gets lost. He's investing in a company. Son didn't seem to do anything, didn't fritter the money away. There was no fraud, no deception, no nothing else that might be a purpose of a lawsuit in this particular case. So really, Kim couldn't have sued in the first place. And because Kim couldn't have sued in the first place, he had no legal right to do that in the first place, he's actually not giving up anything in this scenario. So there was no actual consideration under this particular scenario. So in that particular case, court would not require Kim to pay back the $170,000 because, in fact, there was no consideration in that contract. All right. All right. Adequacy of consideration. This is what we talked about before in regards to how much consideration, whether somebody have a little bit of value or a lot of value, or anything. The court's not going to get into a situation of measuring exactly what the value was and was it a fair contract. We're not getting involved in that. Was there some measurable value? Here's that peppercorn rule that you will need to know for the test. The peppercorn rule is court's not going to get into valuing the consideration. If there is any value at all, then you have consideration, i.e. if it has enough value as a peppercorn, then the court's going to be satisfied that consideration was there. All right, now let's talk about some exceptions to consideration that the courts have sort of said, look, that's not consideration in situations, right? An illusory promise is not considered a consideration, right? If the acceptance is only a promise and not really committing oneself to something, then it's usually not consideration. Like the idea is, that's a great bike. I think I'm going to buy that bike, right? I agree. That $50 is a great deal. That bike would be great for me, right? That's an illusory promise. I haven't really agreed to pay you the $50 or anything like that, right? So if that's the type of situation, when one person is not really committing himself, the court's not going to find that to be consideration, all right? Blockbuster, I think in the book, the example was Blockbuster had a provision. If you guys remember what Blockbuster is, Blockbuster, I should preface this. back in the day, right, when you are all pretty young, DVDs and VHSs was what we used to entertain ourselves, and Blockbuster was a company that nationwide company that allowed you to go to there and rent from them these videos. They had a policy that basically said if you do this, then you have to buy it, kind of a thing. And it would fluctuate, but you always, whenever you did your contract, you were always agreeing to, and every time you went in and rented a video. The court said, look, there really is not an agreement here. It's not a situation in which Blockbuster is really giving up any consideration, because it was really them sort of saying we may do this, may not do it, kind of a thing. So it's really wasn't considered consideration. All right. Pre-existing duty. General rule is it is not consideration, right? So remember our scenario we talked about last time where I agreed to mow your lawn for $20 for the next 4 weeks, with the understanding that the only way for me to accept your contract of paying me the $20 was to actually go mow your lawn, right? So if I went and mowed your lawn 4 times, you now have a pre-existing duty to pay me $20. If you came back to me and said, look, I'm not going to pay the $20, but will you take 60? And I said, sure. I'll take 60 instead of the total 80, right? 4 weeks times 20 per, right? $80. Fine. Give me the 60 because I know I'm not going to get paid at all, and I don't want to take you, sue you, and it'd be difficult, and so just fine. I'll just take the 60, right? If I wanted to, I could still turn around and sue you for that other $20 because you already had a duty to me. There was no consideration, therefore we had no contract, right? So the general rule is pre-existing duties do not rise to level of any value, right? So now, if a party already required to do something, but both parties agree to rescind and create new contract or agree to modify the existing contract, this can be consideration, but here's the only 2 scenarios in which that happens, right? We'll talk about those situations here in a second, actually. Past consideration. If a completed act can't be used for consideration, I just talked about that. I already mowed the lawn, so you can't use that as some sort of consideration in a contract, right? So additional work or a modification of work happens all the time in construction scenarios where somebody wants something differently, different type of cabinets, different type of flooring, whatever it may be. That's a modification, or they've decided they want something addition done, right? You can do all those things and then change the entire contract because there's something different happening at that point in time. All right, so additional work or modifications can be used as a consideration. If there were unforeseen circumstances, again, let's go back to that house. I'm building that house. We get in there and we realize there's something wrong with the foundation. There's some water, whatever. There may be some spring under the house, which means in order to build the house we're doing, we have to do differently with the foundation, right? Since neither of the parties, when they got into that bargaining, understood any of those scenarios, they were completely unforeseen, then there could be a new contract that could exist, even though it's exactly the same contract before, but there could be a change. That could be, the court can consider that actually new consideration because the contract wouldn't be worth the contract you're going into because of what it would take to get that house and foundation. And at the same time, the builder or the new homeowner wouldn't want the house being built without considering the water because it could mean the house be destroyed in a year, and therefore neither parties would want that to be done, right? So circumstances that parties did not or could not have reasonably foreseen when making the contract is what we're talking about by unforeseen circumstances. All right. All right. Settlement of debts. This is where I talked earlier about there can be situations in which the court will consider past consideration, debt, right, as a form of consideration for a new contract, right? So in liquidated debt, there's no dispute about the money owed. Remember we talked about the scenario where I have mowed the lawn. There is no issue at all. You owe me $80. I mowed your lawn 4 times, $20 a piece, $80 in total. If it is a liquidated debt and we know exactly what it is, then giving some money, that's $60 we talked about giving me instead of the full $80, to wipe out the entire debt does not equal consideration, would not be considered a new contract. I could still turn around and sue you for the $20. Now, if the debtor offers a different performance than does that can extinguish the entire debt, right? So if it was, all right, I'm not going to pay you the full 80, I'm going to pay you 20, and then I'm agreeing that you can have this, right? We're good. That's a brand new contract. We're going to say whatever this is, that equals whatever. You guys agreed that would equal the $20,000. Could be a bargaining situation, right? Maybe you're an attorney and you're going to give me free legal advice on my next potential lawsuit. Okay, the court's going to consider that consideration at that point in time to take up that $20, right? If it is unliquidated debt, which means we don't know, right, about what is actually owed. There's a dispute. Maybe I've been mowing your lawn for 5 months or 6 months, and it's hard to tell. You know, some months have 4 weeks, some months have 5 weeks, right? It's hard to tell exactly what is owed to you. I can't remember. Bad bookkeeper. Hard to say. I think you owe me $500, and you think you only owe me $420, right? Whatever. We don't know. Parties are disputing what the amount actually owed, or we're disputing there's any amount owed. I never agreed to mow your, I never agreed to pay you $20 to mow the lawn, so I have no idea why you're mowing the lawn, even though I watched you mow my lawn every week for the last year. But, right, any of those situations where parties dispute there's any amount owed, or parties dispute this, what the actual amount owed is, we can reach a new agreement. All right, I agree to pay you $450, right? And that situation there, that's called an accord and a satisfaction. That is a new contract. That is both people giving up something of value in that situation there. So even though there was a pre-existing duty to pay in that situation, because it was unclear as to what it is, that accord and satisfaction is a new contract that's a legally binding contract. All right. Let's get into non-compete agreements. So non-compete agreements are those type of agreements in which you, as an employer, or sometimes it can be an independent contractor, agree not to do certain things that compete with somebody who's going to be likely paying you money. The biggest non-compete agreements come in the way of employer-employee types of relationships. For Oregon, non-compete agreements are found under Oregon Revised Statute 653-295, right? If you remember, right, that's Chapter 653, and then Section 295 is kind of how it works under Oregon statutes, right? And so here's how the non-compete clauses work in Oregon. An employee must receive at least 2 weeks of notice of the non-compete, or must be paid part of some new bona fide advancement. My sister recently she worked at a company, got some new ownership. The new ownership, as a result of coming in, lost some folks who went to compete against them. They wanted to stop the talent from being taken in that situation. So they required all the new staff to come in and sign these non-compete agreements. The problem, as I told my sister, is I said, did they give you any advance warning? And she said, no, not really. And I said, was it part of any new benefit structure, or any bonus, or any raise in your salaries? And she said, no. And so I told her, it's up to you going forward, but really this is probably not a valid non-compete agreement. And if you wanted to leave them, and she had no intention of leaving them, she likes where she's at, they probably couldn't bind you to this non-compete agreement. So it has to be part of something new compensation, right? There has to be consideration, right? That's kind of how it all works. And that's why the courts have said, look, you've got to give them an advance notice, and if you're already paying them and nothing changes, there needs to be something changed for there to be consideration. Otherwise, it's not a valid contract. Employee must be exempt employed under state wage and hour law. In other words, they have to be an employee that does not qualify under the wage and hours, what's called state wage and hour laws. If they're in that status, you can't require them to sign a non-compete agreement, right? It's because they're not being paid a huge amount of dollars, and to require them to, have to wait or not get the same type of job in your community is just not going to be good public policy. Employers must have a protectable interest. They can't just be willy-nilly saying, we just don't want you to go over to the other mom and pop store, so you have to have something, whether it's certain types of software, certain types of processes, whatever it is. There has to be something, clientele lists, something like that, that's protectable. And otherwise, again, non-compete agreement is not going to be sanctioned in Oregon. Employees' annual gross salary must exceed the median income for a 4-person family. Again, if you're not paid very much, you're in that lower income bracket. So currently for a family of 4, it's $70,000. If you're under that status, they can't require you to do a non-compete clause, right? And none of them can last longer than 18 months in Oregon, right? Those are sort of the qualifications for Oregon's non-compete law. If any of those apply, as I told my sister, it's voidable, right? It's not that it's void, it is voidable in that particular situation. All right, and just so you know, I didn't tell my sister any legal advice. I just kind of went over what this all says, and then she took the information that she had to make those calls. All right. Sorry about that. Sometimes the computer starts to shut down, so I had to stop it, restart it up here. Kind of continuing on with consideration. Now, there are times where something might occur where, although there was not proper consideration, somebody benefits. Remember, we've talked about what promissory estoppel is. It's where the court acts in equity to say, we don't think there's a fair situation here. We're going to try to create fairness. And again, you have a situation where somebody promised something, somebody relied on that promise, and then as a result of relying on that promise, there is some detrimental situation to them. All right. An example of that is one party agrees to donate land for a new store to Salvation Army. They rely on that promise. They go out and they spend time, money, and they get some other donations for materials to begin to build the store. And all of a sudden you say, no, I'm not going to give you that land. And the argument is, well, you never gave me any consideration in that situation. Once you've made that promise and they detrimentally relied on that promise, we're going to hold you to that at that point in time, right? So that's one of the ways in which promissory estoppel may work. All right, let's talk about violation of public policy again in these non-compete agreements. I'm going to kind of go back to them. I know my slides were going back and forth, and I apologize for that, but it's just kind of the way they were set up to make sure we're kind of still on consideration in those situations where somebody promises something, you act on it, and they don't fulfill their end of the promise. All right, going back to public policy regarding non-compete agreements, here's what I want them, and these are the key things. These 3 things are the key things. It has to be reasonable duration. It has to be specific activities and reasonable activities to prevent them from competing with you. And the territory has to be A-right. So in other words, if it's something that's very specific to your community, it has to be within that community. You can't say nationwide, right? If it was, say, for example, a hair salon, and a hair salon has you sign an agreement because of their client list, and it's something they brought in and processed, maybe they do the haircuts, whatever. They would have to be a reasonable time period, a reasonable, you can't do this particular type of cutting, and you can't do it in this particular territory, right? Not nationwide. If you wanted to move 100 miles away to do your hair cutting, that non-compete clause probably wouldn't prevent you from doing that. So that's the key. Key in reasonable duration, activity, and in territory. All right, wanted to put this in. You guys know me. I'm sort of a, when I do tables and or visual stuff, it's very helpful to me. So I put this in there for you all to use for studying for the tests. Again, if the contract is more likely to be enforced if it involves trade secrets, confidential information, those type of things, then the courts, so long as the duration and the geography is not too far, from being too unreasonable, I should say, then we're going to uphold those. Customer lists developed over extended period of times, those are going to be kind of, we'll take a good look at, okay, we get that. It may just be you can't use anybody off that list, right, to compete, something like that, but we're still going to lead to finding the non-compete agreement to be valid. Limited time and geographical scope. You have trade secrets, confidentiality, customer lists, and you don't do it nationwide or statewide. And the time period is, a year, 18 months. Okay, again, we're probably going to be good with the courts. And the terms of that non-compete are essential to what it is, trade secrets, confidential information, right? It's clearly RASHM related to all those, right? You can't do any work of any kind anywhere, right? That would be wrong. It just got to be that type of work. We talked about the haircuts, right? If you wanted to go work at a restaurant or a bar or go work for an insurance company, you could do all those things. The non-compete clause would have to be specific to the cutting of the hair, right? That's kind of what we're talking about. If all those things are there, court's likely going to enforce it. Less likely to enforce it if the employees had already had the skills when they began the work, if that customer list can be derived from, public sources, if your customer list came out of the white pages or something like that, well, anybody can have access to that, so that's something that the court's not going to necessarily find binding. If it's, again, 3 years, 5 years, and it's nationwide, then again, we're not going to do so. Or if it just seems like it's not related, it's unduly harsh, then it's against public policy. That's really, really rare. Excuse me. All right, so there's kind of a graph for you guys to kind of take a look at what the court's going to look at. All right, so my computer once again is going a little slow. Here's the keys to consideration. Both parties must get something of measurable value. All right, sorry. All right, I went through that a little bit, but those were the elements of consideration. So now we're moving to legality, right? The contract must be for a lawful purpose. If not, it's void. Not one of the parties can pick and choose that they want to get out of that contract. No, that's voidable. In this situation, because it was not something that legally could be done, the court's just going to terminate that contract. All right, let's talk a little bit more about legality. All right, legality, will the court enforce the contract? 2 categories to consider. 1, does it violate a statute? And then 2, is it bad public policy, right? Statute's the easier one. If it violates a statute, clearly it's not legal. Bad public policy is more of where the courts have said that in this particular situation here, to allow that contract to be enforced would not be good public policy going forward, therefore making it an illegal contract. All right. All right, so let's talk about violation of statute. Wagers, illegal unless law specifically allows for the type of gambling, right? And it's void. So, for example, here in the state of Oregon, if we made some contract regarding slot machines and that you're going to provide 10 slot machines for me, and you're going to put them in my business and not going through the state lottery, they aren't those types of machines, then that's an illegal contract, and nobody would be held to fulfill the terms of that agreement on that contract, right? I talked about the drugs, right? Selling of drugs. There's a great video about, I can't remember, I think Jonas Small is in it, if I remember right, and he goes to buy some marijuana. Goes to knock on his dealer's door. Dealer's not there. There's another guy sitting there, and they make a deal for, I think it's $300 for some amount of pot. And then the guy turns around, pockets the $300, and never gets him the marijuana. And so Jonah Hill's like, well, dude, we had a deal. Well, he couldn't go to the courts and say, I'm suing him for a breach of contract. We made a deal. I offered to pay him $300, and he offered to give me some marijuana, and he breached. He didn't give me. I gave him a $3. He didn't give me the marijuana, right? Because it's an illegal contract to begin with, right? So if it's illegal, it is void. The court's just not going to care, and nobody is going to be required to fulfill any of the requirements. All right. Insurance. Insurance usually is only enforceable to the extent party had some insurable interest in the insured persons. So an example might be requiring a life policy on somebody who buys a new motorcycle. So where if they die, you get the benefits from that life insurance policy, right? So that individual ends up being worth $2.5 million, right? And you sold them a bike worth $5,000. Court's not going to enforce that life insurance policy or require you to buy a life insurance policy. It will require you to buy insurance that covers if the bike were to be destroyed to compensate them for the $5,000 you agreed to pay on that bike, but only enforceable to the extent the party had some insurable interest in that particular person. All right? Otherwise, it's a void contract. Licensing. If a licensing statute is designed to protect public policy, for example, lawyers, doctors, electricians, plumbers, all of them have to go through certain requirements to have a license, and they have to have that license in order to do the work that they do, then any contract made by an unlicensed person is unenforceable. It is void. The court's not going to require anybody under that contract to move forward under that situation. All right. Usury. Usury is usually when it comes to interest rates. It is where a contract requires somebody to pay back some exorbitant amount of interest rates in order to get the loan in the first place. Those are usually void. And that's really kind of can fit in that bad public policy, but we have a statute in Oregon, ORS 82010, that talks about what usury is and what the limits are. If you're within those limits, good to go. And Oregon allows for some pretty high interest rates, but you couldn't require 75% interest rates. That would probably be usury, and the court would void out that particular agreement. All right, you still have to pay back the principal, but not the interest on that. All right, you guys get to be the judges. All right, and I think this is the case that was in your book. Husband and wife use vitro fertilization to start their family. The process yields fertilized eggs, which were frozen for possible future use. Wife had written on consent form, which can be construed. Consent forms are contracts. And husband had signed it, and that if they separated, she could still use those embryos in the future. Years later, while married and not separated, husband finds out when he's billed by the insurance carrier that wife had used one of the pre-embryos. Right? They separate shortly thereafter. During the divorce proceedings, husband asked for an injunction to forbid her from using any more of the embryos, and the divorce court decides wife's right to impregnate herself or allow others to use them, quite frankly, is what they said, did not outweigh the husband's right to not have children out there that he did not want. In other words, the court said in this particular situation that was not a legal contract, right? And or, more importantly, it would be bad public policy to allow somebody out there in this situation to have the other person's embryos out there not knowing who, what, where, when, and or selling them. Quite frankly, is one of the things that she was thinking about doing, was selling them to other couples for use as well. All right. Things for you all to consider, because we've talked about ethics being an important part of this class. And remember, whenever presented, do the ethical thing. So think about some of the ethical issues of this and why this might be bad public policy, why the courts determined that it was bad public policy. And should this have been avoidable? What if the man would have said, look, I'm okay with this, and then later on determined, maybe I'm not okay with this, right? Should he have had the opportunity to, or either one had the opportunity to say, no, it's voidable, we want to get out? Or should it just be, as a matter of law, in this particular case, just void? Right? There are some additional facts that the court did consider. It appears that husband signed a blank form, and so there was a question about, did he really consent? Right? That's the other element we're going to talk about, right? Did he really consent to that? She filled in marks and boxes. It appears after he had signed it, He didn't realize, so again, that she was going to mark that box. She did so later on, so then there was another question out there, was it really in a contract in the first place, because she changed what he had actually signed. Right, so then you have that no meeting of the minds type of a situation, therefore not a contract as well. All right, hopefully that all makes sense to you all. Let's talk again, continuing on with legality here. Exculpatory clauses. A contract provision that attempts to release one party from liability in the event of an injury. Many of you may not, especially if you're a snow skier, you sign these every time you go up to the mountains. You agree not to hold the slopes companies liable, right, for any injuries that you have. And the courts are okay with that, right? We want to promote people to use different types of facilities and have facilities available for people to use, and we understand that life is not so simple, as we've learned currently, that sometimes you have to take risks in life to enjoy life. And so in order to go down a hill where you might be going 30-40 miles an hour, there might be some trees there on the way, or whatever it might be, or you can't have perfect snow, so there might be moguls that you're not ready for. Whatever it is, you determine you want to do that high risk behavior because it's a lot of fun. Well, we're not going to hold them liable if you get hurt in that situation, because we know it's a high-risk situation, ice skating or something like that, right? When you play ice hockey or you do any of those sports, you usually have to sign, I agree not to hold the facility liable if I get hurt, because I know it's an activity, sporting activities. You can get hurt playing sporting activities. You can't hold people liable for that, right? Now, that said, what you need to understand is those are generally not enforceable for intentional torts or gross negligence. Remember, intentional tort would be, look, if I go up on the ski slope and you decide to hold me on the ski lift for 3 hours because you're trying to figure something out. I didn't agree to be up on that ski lift for 3 hours, and so you're kind of maybe kidnapping me or doing something intentional, right? Then maybe you could be sued. Or if you knew that there's a hole in the slope, it's right where kind of people do their runs, and you're like, I don't care. They've given me an exculpatory clause. I'm going to go ahead and let that hole stay out there. It's their job to avoid it. You don't put any markers up. You don't do anything. Well, then that could be considered gross negligence, and you could be sued for that situation. Okay? You cannot have people sign exculpatory clauses saying you can never sue me for anything. If it's an intentional tort, or if they are gross negligent in their activities, then you can still sue them. Generally not enforceable if the activity is clear public interest. Right? So what I mean by that is if, for example, the airlines companies were to try to get us to sign off on some sort of exculpatory clause, we need airlines, we need to get from one place to another. They have the specific skills and planes and locations, right, that we don't have access to. It'd be hard to get access to, but in order to keep functioning in society, we need to be able to fly. So that type of a public interest means the airlines aren't going to be able to sign us to agreements saying, hey, as long as we aren't gross negligent, then you can't sue us. So even if they're negligent, they're plane crashes, they do something they're not supposed to do, you can still sue them because it's public interest to have all of us flying, and they really have control everything, and we would have no idea what their maintenance is and stuff like that. So we're going to hold them accountable in those situations, right? Medical care, right? You couldn't every time you walked into a facility have to sign an agreement saying, I will not sue you for anything that you do, right? Medical malpractice type of situation. No, they can't do that either. We all need medical care, so it'd be bad public policy, right? So exculpatory clauses, kind of to go back over, it's a situation in which it's a contract. And you're agreeing that you're not going to hold them responsible, knowing it's a dangerous activity or it's a dangerous location or whatever it may be, but that's something that you want to do, right? Unless they are intentional, some sort of intentional tort or grossly negligent, you can't hold them. Those are valid. Those are going to be valid contracts in those situations. unless it's bad public policy, and I've kind of given you a couple of ideas where the courts have come back and said, yeah, bad public policy in those scenarios, we're not going to allow them to require you to sign exculpatory clauses. If they do, we're going to void out that particular exculpatory clause. Okay. Generally not enforced with clearly unequal bargaining power. Again, that's kind of what I talked about the airlines industry. We have no idea what the plane's maintenance. We wouldn't know how the engine goes. We don't have access to any of their landing facilities. No idea. And yet we need to get back and forth. They're not clearly, the airlines have a clearly better position to bargain than we do. We need to get from place A to place B, and the quickest way to do that in our lives, right? We only have X amount of vacation days, whatever it may be. We may need to get there in 24 hours because somebody's dying. Whatever it is, we're in a society where we've decided you can be split apart and still need to get places quickly, and the airlines would be in a clear, better bargaining position, so unequal that we said, again, we're not going to allow you to require people to sign exculpatory clauses. Okay? And again, they're also generally not enforceable unless they were clearly visible in the first place, right? You knew exactly. And usually it's you initial something, you check something that agreed to this particular situation, right? And you sign them all the time. Again, those apps that we talked about that you have on your phones, you usually agree not to sue them if there's something happens to your computer, unless they were, again, grossly negligent or the program was so bad that it infected your computer, whatever it may be, right? It has to be, again, kind of a gross negligence situation. It has to be clearly visible, and usually they are. You have to say, I agree to all these terms, and that's how it works. Okay. Let's just skip the bailment relationship. It's not going to be on the test, and again, that's not that important for to worry about. All right. Again, you guys get to be the judges. So you go out, you get your first job. You're tired of mooching off your parents, so you rent your first apartment, right? It's got a swimming pool, workout room, laundry room, and grassy commons area, all the amenities that you've always wanted. When you sign the 8-page rental agreement, you are required to initial a part that states Boxer Apartments are responsible for swimming pool, workout room, and common areas, and you agree to use the above amenities at your own risk. Having failed to read your business law course materials, you put your initials down and eventually sign the agreement on the dotted line in blood. Ready? You're so excited. In another section that you initial the agreement, the says Boxer's Apartments are not responsible for any harm to any tenants or guests caused by Boxer's negligence, right? That's an exculpatory clause. As the weather got better, you and your friend are playing Frisbee in the common area, and your friend led you a little too much, causing you to run and fall into a hole dug a week earlier to plant a new tree. You break your leg. All right, can you sue? Well, as we know, you can always sue. But the question is, do you have a really valid lawsuit in this situation, right? Was the exculpatory clause valid in this particular case? And is there a public interest in voiding such a clause, right? So can you sue? Yeah, there are situations here where it'd be arguable that it was gross negligence, and they had a hole in a commons area where they knew people would play. They didn't mark it. They didn't put anything down there to let anybody know that there was a caution. Don't be around this area. Anything like that. So there's an argument to be made that although the exculpatory clause was valid, there doesn't seem to be anything, right? Was there some unequal bargaining power? No, there was lots of different apartments around. You could have chose any different apartment complex you wanted to. So it's really not unequal bargaining power in that particular situation. There's no bad public policy. There's no statutes that prevent them from putting them in there. So yeah, exculpatory clause is valid. Now, is there a public interest in voiding such a clause? Again, I don't think so, and I don't think the court would. However, in this particular case here, what I think the best argument would be is, look, they understand that it's their commons area. I can't do anything in there. I couldn't have filled in the hole. I couldn't have done anything, and they should have clearly had filled in the hole or provided with notice that there was a hole out there, that somebody could get hurt, and so they had an obligation to not create a situation in which I could get hurt, and therefore they are acting gross negligent, and therefore I'd sue them under a gross negligent policy, which, as you remember, under exculpatory clause, you cannot prevent somebody from suing you for gross negligence. All right, that is you all getting to be judge. All right, unconscionable contracts. These are situations in which the court finds that they're just bad, huge, horrible public policy, right? So this is kind of that caveat to illegal contracts being void. Unconscionable contracts, right? Remember the rule is if it's an illegal contract, it's void. This is a caveat that says in a few situations where although we're going to find it to be an illegal contract, right? It can be voidable, right? It's not per se void, and that's unconscionable contracts. Becomes a voidable contract. There are two factors. One, did one party have clearly superior positioning in the bargaining? We talked about the airlines industry, right? So in the situation in which, say I buy my ticket, but the airlines requires me to sign the exculpatory clause, right? That's your setup, right? Surprise, no, they made it clear, did everything right. If it is a surprise, they hid it. They just basically, when I signed agreeing to pay for everything in that contract on page 3 of 9 in smaller print was this exculpatory clause, right? In those situations, I can make a decision that I don't want to go forward, therefore it's voidable by me. The airlines are stuck with it. Whatever their other agreements were in there, the whole contract doesn't get tossed out. What the court's going to do is just get rid of the exculpatory clause in that situation, right? Again, airlines has clearly higher, better bargaining position, and so it's kind of impressive for them to require me to do that or for me to fly and be buried. It was surprise, it was weak, and so those situations there, again, doesn't make the entire contract, doesn't even make that particular part of the contract void. I can determine if I want to go forward on it or not. I can make it voidable. Okay. There's what's called an adhesion contract. It's a standard form contract prepared by one party who likely has an upper hand in the deal and presented as a take it or leave it proposition. Sort of that Hobbesian choice. You can have this horse or no horse, right? You're looking out and there's 100 horses out there. That's the choice they give to you. You either have this horse right here, which is the weak one, or you can have no horse and you desperately need a horse. Sign this contract saying you agree to that particular horse, right? They have the upper hand. It's a standard contract, requires everybody to do that. Those types of contracts sometimes are found to be bad public policy and are voidable by the person who had to sign that particular contract, right? You get it all the time in, like, in these app types of things. And if it were so oppressive, so, all our apps, we don't have to sign on. There's so many out there. There's nothing that would be required of us. There's not some really unequal bargaining position, even though it is a take it or leave it type of situation. If you don't agree, then you don't get to use that app. It's not the type of situation where the courts are going to say, yeah, that's an adhesion contract, therefore a voidable situation. All right. Generally enforced, but come with some great scrutiny by the courts. That's as indicated by you. Usually the courts are going to allow those unless, again, it was clearly unequal bargaining power and clearly some bad public policy or something of that nature. If the court doesn't find any of those, then the court's going to allow that contract to go forward. All right, so let's talk about elements of contract again, because we're going to be moving on to capacity and consent. All right, so sorry, I'm going to turn my phone down here. It's going like crazy all of a sudden. All right. So again, we've talked about the offer, we've talked about acceptance, we've talked about consideration, we've talked about capacity, or we talked about legality. Now we're getting into capacity and consent. I've combined the two because Chapter 15 combined the two. They are two separate elements, right, of a contract. Capacity is not the same thing as consent, and so you have to have both capacity and consent in order for it to be a valid contract, right? So if you don't have capacity or you don't have consent, then it is a voidable contract by the person who lacked the capacity or the consent, right? The contract can still go forward. Both parties can actually perform under it if they want to. If you're the person who lacked the capacity or the consent, you can still require the other person to perform under that contract. There may be good reasons why you want them to do so anyways, and so you can require them to do so. Only you who lack consent or capacity can void out or make it a voidable contract. All right. Capacity is a legal ability to enter into the contract. there can be age or mental infirmity, right? In most states, there is a age level. Usually it's 18. And once you turn 18, you are now legally able to enter into contracts. Prior to that, you were considered a minor and are not legally able to enter into contracts. So you go down, you get your new car at age 16, you want to put a brand new stereo in it, you go down to the car stereo place, put it in there, you agree to pay them $1,200 for them to do all this labor and put this new stereo and speakers and subwoofers and everything into it. They start to go forward after you've signed everything, and you realize, I can't afford that kind of money, and you could go to them and say, stop, I'm not going to go for it. Now, there's a question as to if they've put the stereo in, you're going to have to either give them the stereo back or pay them for the stereo, right? You can't completely walk, so I don't want anybody thinking you can do that. So you're still going to have to give them either the stereo back or pay them the value of the stereo, right? Basically, it's what their cost would be for that stereo. Sometimes some courts require cost plus you're going to have to pay them for what they could have made on that particular item, depending on the particular state. But it's voidable by you, that minor. Also, if for whatever reasons you are mentally deficient or at a lower IQ or whatever it may be, and such a low IQ that clearly you're not able to form consent or have the capacity, I should say, to enter into a contract, again, that could be voidable by that individual. All right? Disaffirm means to give notice of your refusal to be bound by the agreement. That's what I talked about, right? You would be disaffirming the stereo contract by coming and saying, stop, I don't want you to do this anymore. I don't intend to go forward on this contract, right? That's disaffirming it. Rescind means to cancel the contract outright. They could be basically the same. Disaffirming is just letting them know that you're giving them notice that you're not going to go forward, and then rescinding is just to cancel the contract altogether. Now, restitution, again, like I talked about earlier, don't think you're going to be getting away. The court's still going to require that minor or mentally infirm person to return the other party to how they would have been before the deal was made. Now, they don't get the full, right? They don't get all the labor. They don't get all those. They basically either get the item back, which is where they were before, or the item back and some sort of compensation if it's already in, right, the car, say, going to get them whatever fair market value is to make them whole for their time lost. Right? Status quo rule is only must make up the profit difference. That's what we talked about before. If there's a situation in which the court can, still give them just their profit, that's about all the court's going to do. Not going to go any further. Not make the parties follow through with other parts of the agreement. All right, that's capacity. Right, the mental ability to do something. Again, even age is the mental, right? We just don't believe minors have the experience to make these types of decisions. So again, it's the mental ability to do something. That's really what capacity is about. Now, consent is I may have absolutely the mental ability to make an agreement, but as a result of fraud, as a result of not understanding everything, did I really consent to what we ended up doing? Did I really know everything and going in and agreeing to do whatever it is we agreed to do? So consent is whether the contracting party truly understood what the party was getting into and whether they did so voluntarily. Right? If a person suffers from a mental disorder, if they are unable to understand the nature and consequences of a transaction. It's one of those mental disorders are one of those where really it's a capacity consent type of a situation, right? They don't have the capacity to enter in the contract, and maybe they do, right? But did they really then, as a result of that low capacity, all right, maybe it was enough to reach the legal threshold for capacity, but did they really, as a result, understand what they were getting themselves into? So that becomes a consent type of an issue, right? Understanding all of the consequences of a transaction. It's a voidable contract if somebody's been previously found insane, it's void, right? Those are consent types of issues, right? All right, fraud is another consent type of an issue, right? It is avoidable by the person who the fraud was committed on. Fraud means a party knew or recklessly made a false statement. They're the bad person. They can't void out the contract, right? So the false statement was material and very important to the deal, right? You've heard of situations in which maybe there was some water damage done in a house previously as a result of a flood. That would be information that if you'd known that, because there could be foundation issues, that's something that you would have wanted to have known or should have known before you entered into the deal, right? So that's a situation where if you ask that question, did they have any flood issues? Was there any flooding? Did they have any and the person said, no, nothing. This was not in the floodplain. No water ever got. No, that never happened, right? Well, that was clearly important to the deal. The situation is that information, and that false statement led you to enter the deal. If you found out that it turned out to be untrue, then that's a situation in which you could go back and have that contract voided out, right? The injured party justifiably detriment relied on that promise statement, right? It's clearly that I would never have purchased that property had I known, and I could get out of that contract. Now, non-disclosure of material fact in situations, again, say that's that same house that I'm getting ready to purchase, I don't ask the question whether or not it was involved in recent floods. But the real estate agent knows that it has been, and they don't tell me that it has been. If that realtor relationship is a special relationship in your community or the court determines it to be a special relationship, then that non-disclosure may make it a situation in which you could void out that particular contract, right? You being the person who wasn't given the information from the person in which you had a special relationship with, right? Those real estate, environmental, health related types of issues are usually the situations when the court says there was a special relationship. That's information you should have told them, and by not telling them, that means they can get out of that contract by voiding it out. All right, mistake is a voidable contract situation, right? Where, so I believe one thing, you believe another thing, but it turns out neither of them are particularly true. The situation we have that was in the book was called the barren cow named Rose, right? The farmer who owned Rose thought she was a barren cow, couldn't have any offspring, and so that made her value X compared to Y. So the farmer sold to another farmer who also believed it was a barren cow, and so therefore the deal was significantly less than if Rose was able to produce offspring. And then it turns out a year later, sure enough, Rose is able to have offspring, not a barren cow. And so in that situation there, I, the farmer who sold the cow in the first place, come back and said, wait a second, you either need to compensate me because actually she can, or I'm going to void that out, I'm going to take Rose back, right? That's the type of situation that it was a bilateral mistake. Both of us thought one thing, it turned out neither of that was true. You can have situations where it's a unilateral mistake. We'll talk about those situations in a second, right? So that's a bilateral mistake because both of us were wrong. A unilateral mistake means one party assumes some factual error. An example might be, I've got a collection of a bunch of different posters in an area in which they're all autographed by the original artist or athlete, whatever it may be. And in that same area, I've got another poster that has a electronic type of signature, or a signature that's not actually done by the athlete or the actor, right? It was done by a computer or done by a secretary who signs situations, right? There's a lot of, back in the day, there were a lot of times where secretaries or a person derived by a president would sign all those. It wasn't the actual president signing the paperwork. But I got them all in the same area as if, right? So you knew, you who owned the shop knew that that was a electronic signature or a secretary signature, but the person who bought it did not, believing it was a real signature by the actor or athlete in that situation. That's a unilateral mistake. So I paid a lot of money for it, I'm thinking it was one thing and it wasn't. I could come back and say, that's a voidable situation. I want to give this back to you, and you gave me back the money that I paid to you because I was mistaken in that situation. Right? That's a unilateral mistake. Enforced contract would be unconscionable or other party knew of the error. In other words, you put it in there, you knew it wasn't, right? You put it into that section. Maybe you kind of purposely put it into that section so people might think that it's a real signature. You didn't tell them that it wasn't a real signature. And so in that situation, again, we're likely going to let somebody get out of it. Right, duress. Duress is a situation where you make an improper threat, you to force a party into a contract. Maybe you threaten their family. Maybe you threaten, if you don't do this now, this deal is going to go away. It'll never be there. When in fact you know that it's always going to be there, right? What's the? Trying to think of the physical fitness place that. Always talks about how we're going to give you this deal if you sign up now. Well, you know that deal's always there, and if they know that deal's always there, right? And perhaps it's an improper threat. Not likely, but you get the picture that I'm trying to paint. An improper threat made to force another party into that particular contract. If you don't do this now, X is going to happen, Y is going to happen, right? You have to do this now. In that situation there, if that wasn't a real threat, or if that wasn't really something that was binding or something that was going to happen, then that could be considered a duress type of a situation, and therefore a voidable, right? You, the person who was in place in that duress situation, could void out or have that contract go away, not have to do it, perform. Factors the court looks at is did the act have any legitimate business purpose, right? Was there greatly unequal bargaining power? Did there general unilateral gain from one party as a result of that? Like, if it turned out I told you, look, you need to get this done now, and it turned out I make the same amount of money either way, right? There's no real different, it's a business transaction, it's done all the time, then the court's probably not going to let you out of that particular contract. You're going to have to show that there's clearly unequal bargaining power, there's clearly some unequal gain, that there's clearly you would never have entered into that contract if you would have had the ability to make an informed decision. All right, and usually it's going to require that there's some financial burden placed on you as a result of that would have been different than had you entered that contract otherwise. Okay. Undue influence. Undue influence is a special relationship and improper persuasion by the dominant party, right? This is going to be a situation like maybe medical, right? A doctor, you've got this torn meniscus and we need to do a major knee reconstruction and put a brand new knee in there versus cutting it out and sewing it up, right? Well, you're relying on that doctor for their expertise in that situation, and you agreed to allow them to do the surgery when you didn't have all the information. They never told you that they could clip it off. They never told you that they could sew it up or anything like that. They told you, no. So you're relying on that, and you would never have done it had you known otherwise. That's a situation in which you might be able to get yourself out of that contract, right? If you had to pay some money in advance, and then you found out later on before they actually did the surgery that, in fact, there's different ways in which you can go about it. All right, that's all the assignments that we need to do for our next class. And again, I'm going to try to get everything online for you all so you can go at your own pace. Remember to turn in via the computer or email your reading questions. We do have a test in a couple more weeks, and you hopefully either got your grades or will be getting your grades for test number 2 here coming up shortly. Again, be safe. Take care of yourselves. Hope everybody's doing okay financially, health-wise, etc. Any questions about anything, you can email me, right? You guys also have my phone numbers, so you can call me or send me a text message, whatever it may be. Don't hesitate. I'm here for you guys, and hopefully everybody's doing well. I'm also, if I haven't done it yet, I'll make sure the extra credit paper is available for you all. I need that extra credit paper before we get into the final, and that's when I usually require it. I may give you a date ahead of time, but I'll let you know. It's not going to be for another 2 or 3 weeks for sure. But that's something if you're thinking might be worthwhile as well. Again, all right. Take care, everybody, and we will see you next time.